Good morning, everyone, and welcome to this meeting of Winchester City Council's Planning Committee, taking place in the Walton Suite of Winchester Guildhall. It is Wednesday, the 4th of February 2026, and the time is 9:30 a.m. My name is Councillor Jane Rutter, and I'm Chair of the Planning Committee. To my right is the Vice Chair, Councillor Jonathan Williams. Around the table, we have the other elected members of the committee, and we are supported today by a number of officers. We have Simon Avery, our Principal Planning Officer, Daniel Lucas, our Legal Advisor, Benjamin Lewis, our Case Officer, and Claire Buchanan from Democratic Services, who supports the committee and operates the recording equipment. This meeting is being live streamed and recorded to the Council's YouTube channel. Subtitles are available, and advice how to turn those on is set out on our website. May I remind you all to ensure your mobile phones and any other electronic devices are on silent or preferably turned off entirely. In the unlikely event that it is necessary to evacuate the building, the fire alarm will sound. Please follow all the instructions given to you by our team. Please make sure you've looked at the handout provided on your chairs or the information slides displayed on the way in for further guidance about this meeting. Finally, can I welcome members of the public to the meeting? Those of you who have registered to speak, I will call you forward when it is your turn to make your contribution. Members of the committee may ask you questions of clarification, so please remain at the microphone until after members' questions. The microphone is turned on by pressing the button on the base of the unit, and a timer will appear on the screen to remind you of your remaining time. Turning now to the agenda, do we have any apologies and deputy members, please, Claire?
Thank you, Chair. No apologies for absence received. All members are present. Thank you.
And any disclosures of interest, members? Councillor Williams.
Thank you, Chair. I need to declare that I have a disclosable pecuniary interest in respect to the only item on our agenda today due to my additional role as a Hampshire County Councillor. However, as there is no material conflict of interest regarding this item, I have a dispensation granted by the Audit and Governance Committee that enables me to speak and vote on these matters. Additionally, I am the County Council representative for the area in which this application is, but I've had no conversations regarding the application.
Thank you. Any further disclosures? No. Minutes of the previous meeting are on the first update sheet. So can I ask, are those an accurate record of the meeting, please? Is that agreed? Agreed. Thank you. So those are agreed. And can we also accept the update sheet indicated as in update sheet number 2 onto the agenda, please? Is that agreed? Thank you. So now we turn to our one and only application today, number 6 on your agendas, which is, get to the right bit, 20 Hazel Close, Colden Common, Winchester, and is an application to remove a TPO. So we turn to our presenting officer, Benjamin Lewis. Over to you, Benjamin. Thank you.
Good morning, all. Thank you for having me this morning. This is regarding an application on a TPO oak tree to remove the said oak tree labelled as T6 as part of ongoing issues related to trees causing damage subsidence.
Ben, can you just speak a bit closer to the microphone, because I'm conscious that Councillor Hill at least is quite hard of hearing.
Is that better? Okay. No problem. Okay, I'll continue with the presentation. This committee is a deferred committee from, I believe it's February actually last year, and it was deferred relating to request for further information, including but not limited to DNA analysis of roots. Okay, come up. So this is the aerial view of our what we call TPO 6, which is as per the application, but within the TPO it is also noted as TPO 1. So it's as tree 1. Apologies. So it's individually protected as part of TPO that was made in 1988, which is 1212 is the tree preservation order number. This tree is has had numerous investigations carried out. We've had levels monitoring, which now exceeds 30 months of levels monitoring of the property relating to trees, this particular tree and its influence. The original application was for 3 oak trees to be removed, and due to previous communication, we have come to the conclusion that T6 is the most likely cause of influence. So this application is to remove T6 only. This is a non-satellite view, so it gives you some context of the site. And this is a visual representation from the road outside of Hazel Close number 20. We would consider this true to provide partial. There's partial view of this when we're considering visual amenity. Over the summer period of this year just gone, or sorry, the 2025 summer, the movement on point 8, which is recorded in the summary report to the rear of the house, has increased by just over 10 millimeters. So I brought this to give some visual representation. So the original movement was 38, and now we are looking at a 48 millimeter movement at one point, which I hope that is clear for everybody, just to kind of indicate the level. We are obviously on review. The further levels monitoring has further indicated that the likely cause is indeed T6, relating to the balance of probability, as is with the case in insurance claims. This is another view from further to the north of Hazel Close, just indicating the canopy of T6. And then again from the most northerly point, looking at the aspect from the top part of Hazel Close. This is the original isometric drawing relating to the movement, which would have been viewed in the last planning committee hearing, and obviously this, just to relate that this actually has the movement to the rear at 0.8 and 7 has further increased in comparison to this drawing. Provided we've obviously our recommendation is to allow the removal of T6 with conditions provided. Thank you very much.
Thank you. We now go to public speaking, and our first speaker is Diana.
Can I just interrupt? Could you just confirm whether it's centimetres or millimetres?
Millimeters. The monitor is down millimeters.
I think you showed centimetres.
No, I think you showed millimeters.
No.
It should be 4 centimetres. 4 centimetres.
Apologies. You're absolutely right. It's millimeters.
Can you show us again then with the right measurement, just so it's not quite so terrifying?
Um,
I mean, otherwise I'm surprised the house hasn't fallen down.
yeah, no, I totally appreciate that.
That's the increase.
Yes. I will have to refer back to the summary report if you will just bear with me. Apologies.
Please do. Let's get this right before we.
Madam Chair, it's page 14 of the agenda pack. If you'll see, there's a paragraph in there from the officers. Principal and legal issues. Updated level monitoring has revealed the foundations of the rear part of the conservatory moved up and down on a seasonal basis by 46 millimeters between the period of April 24 and October 25. The main house has moved up by 25 millimeters. That's an inch, 2.5 centimeters. over the same period, which is an increase of 10 mil. So it's that paragraph on page 14, starting with updated level monitoring.
Okay, thank you very much. I think we're clear now. My apologies, Diana Watts. If you'd like to come forward now, you are the first speaker. You have up to 3 minutes, and the microphone is switched on by pressing the button. The timer won't start till you start speaking, so you can switch the microphone on now if you like, and then when you're ready, if you'd like to start speaking. Thank you.
My name is Diana Watts. I trust the committee have had an opportunity to read my previous objection from the deferred meeting on 5/2/25, along with the important points raised by other objectors. The inconclusive available evidence submitted by the previous case officer, re DNA route analysis, seems to remain, as the addendum engineer's report of 24/11/25 has not supplied any further evidence to indicate T6 is responsible for the subsidence at 20 Hazel Close. They state this is rarely conclusive in mature trees, so has not been undertaken. However, had the committee taken on board a previous objector's comments, she consulted a leading expert in tree-related subsidence damage, Dr. Giles Bedell, in another case. In his book, Tree Root Damage to Buildings, he states, to implicate a particular tree as a cause requires DNA root analysis. He also says insurance companies tend to blame trees without necessarily establishing they are actually the cause. I am concerned at the frequency local authorities seem to revoke TPOs when challenged by insurance companies in subsidence cases. See reply from my MP in this regard. He has asked the Secretary of State for his feedback. I have lived on Avondale for nearly 18 years. In that time, it saddens me to see the cardinal aspect, i.e. the splendid protected row of oak trees, which border Avondale and Hazel Close, greatly diminished at the request of homeowners in this road wishing to build extensions too close to these magnificent gentle giants. I urge the committee to consider carefully the plight of T6 and possibly at a later stage T16 and T4, which are healthy specimens and support humans and nature in so many positive ways and are vital for the environment, as the many pieces of council legislation testify. I do not dispute that remedial works need to be undertaken to resolve the subsidence in this case. However, I am deeply concerned the removal of T6 may be in vain if it doesn't resolve the issue. Additionally, it could cause further issues. Winchester Council could set a precedent to other local authorities by respecting the importance of not rescinding TPOs when challenged, thereby acknowledging their valuable part in our ever-threatened environment. When TPOs were placed on these precious trees, Winchester Council became their custodians. Now that T6 needs your support, please do not let it down.
Thank you very much. And members, do we have any questions of clarification for Mrs. Watts? No, thank you very much. You're very clear. Thank you.
Return this up.
Yes, please. Thank you. If you'd like to return to your seat, that's lovely. And now we have Councillor Maggie Hill from the Parish Council. Good morning, Councillor Hill. You know the routine. You also have up to 3 minutes when you're ready.
Right. I'm Maggie Hill, Chair of Oldham Common Parish Council. When we last looked at the application, the committee decided to defer its decision until some further examination had taken place into the necessity or otherwise of felling the trees in question. The results are still inconclusive. No DNA test has been carried out because it's been found that the roots of the trees are so entwined it's not possible to be sure which tree they relate to. It should be noted that it's by no means certain that the trees have been the cause of the subsidence and that in the past there was another incidence of subsidence elsewhere in the house. We know that drought followed by ground heave after rain is a common cause of subsidence. Therefore, no guarantee that felling any of the trees would resolve the problem. The owners of the property have been trying to resolve the issue for many years. The tree provides essential shade for the neighbouring properties and has been a feature of that landscape for decades. Winchester's tree strategy emphasises the importance of large trees for carbon sequestration and for improving places and boosting well-being, in addition to mitigating the effects of adverse weather, including floods, storm water and wind turbulence. It cannot be consistent with the City Council's environmental policies to assume a default stance that trees should be felled as an automatic response to subsidence problems, even though this may be the preferred outcome for insurers. As the national tree of Great Britain, the oak symbolises longevity, strength, fertility and power. It is a haven for biodiversity. A single oak is capable of supporting some 2,300 wildlife species, 300 of which are specific to oak trees alone. Once a tree of this stature is lost, it's lost forever. I therefore ask the committee please to honour the tree preservation orders on this site, and in particular the tree T6 in question, and to decide not to fell it. Thank you very much.
Thank you very much, Councillor Hill. Members, do we have any questions of clarification for the Parish Council Chair? No? You were very clear. Thank you very much, Councillor Hill. And next we have the ward councillors. First of all, Councillor Sue Cook. You're going to come together. Very good. Councillor Cook, and we have Councillor Liam Bailey Morgan. Welcome. You have 5 minutes each. Yeah, you have 5 minutes each up to.
Okay.
So when you're
Thank
ready.
you. Morning, Chair, morning, members and officers. This is not simply a case of tree versus house. It is a test of whether tree preservation orders are being applied as they are intended as a safeguard of last resort, or whether their protection is being incrementally eroded under financial pressure. Let me be clear at the outset, no one here is dismissing the reality of building movement or the need to stabilise the property. The question before us is whether felling this specific protected oak tree is truly unavoidable and whether all reasonable alternatives have genuinely been exhausted. One aspect of the evidence deserves particular attention. Only part of the house is affected by subsidence, and that part has not been underpinned. Meanwhile, another section of the same building at a similar distance from an even larger oak tree is underpinned and is not experiencing comparable movement. That is a significant anomaly. Seasonal movement in clay soils is not disputed, but seasonal movement alone is not proof that a particular protected tree must be removed, especially where structural solutions have not yet been implemented. This brings us to the importance of sequencing, which is critical in this case. Given the severity of clay desiccation and the presence of high water demand oak trees, the immediate removal of vegetation presents a well-recognised risk of clay heave and associated structural damage. In these circumstances, underpinning prior to tree removal is the only method of stabilising the property against both, against both further subsidence and rebound movement. That matters because in this case, underpinning is proposed only after the tree is removed. There is nothing in the submitted evidence to demonstrate that underpinning could not be undertaken with the tree retained, nor that the presence of T6 makes stabilisation work unsafe or unviable. On the contrary, structural stabilisation first may well arrest further movement without the permanent loss of a protected oak, while also reducing the risk of heave associated with early tree removal. Once the oak is felled, that opportunity to test necessity is lost forever. This is precisely why tree preservation orders exist, to set a high bar for removal, particularly in complex cases like this. A TPO requires that a protected tree is retained unless removal is genuinely unavoidable, not merely preferable, cheaper, or procedurally simpler than alternatives.
Okay, shall we save our questions of clarification to the end, or has anybody got something specific for Councillor Bailey Morgan? No, so we'll move on to you, Councillor Cook. Thank you very much.
Members should also consider who benefits from the tree. T6 is not incidental to a single property. It sits within Avondale Park Oak Mobile Home. Where it provides direct public amenity to nearby residents, it contributes to the character of the park, offers shade during extreme heat, supports wildlife, and as we have heard, is valued daily by the community. That public amenity is precisely what the tree preservation order was made to protect. We would note that the officer's report describes the tree as having a moderate public visual amenity value based on views only from Hazel Close alone. It does not assess the tree's amenity from within the Avondale Mobile Home Park community itself, where the tree is experienced most directly. That omission risks understating the true amenity impact of removal. We are also concerned about the precedent if we accept that a protected oak can be removed on probabilistic evidence alone before reasonable alternatives are fully exhausted. We materially weaken the protection afforded to the other two TPO trees originally selected for removal. Once one oak is lost, the argument for the next becomes much easier. Members will recall that this committee previously deferred this application to seek stronger evidence of causation, including DNA root analysis, which we've heard about. That evidence has not been provided. Instead, we are asked to accept that such testing may be inconclusive, yet the same uncertainty is now being used to justify the most extreme and irreversible intervention available, the felling of a protected oak. Would you submit a sentence to a criminal without all the evidence? Members have also heard reference to potential financial liability, but compensation risk is a known and accepted consequence of making and enforcing tree preservation orders. If financial exposure alone was sufficient to justify removal, TPOs would quickly become meaningless. I'm sure you would agree. Finally, while replacement planting is welcome, it does not alter the fundamental point. A newly planted tree cannot replicate the amenity, biodiversity, or climate value of a mature oak. I'd like to quote something from the Woodland Trust, if I may. Where a tree preservation order is in place, removal should only be permitted where there is clear, site-specific evidence that the tree is the direct cause of the damage, and that no reasonable alternative solutions exist. Subsidence alone does not automatically justify felling a protected tree. It should be an evidence-led approach, given the importance of mature oak trees. The family moved into this home when it was first built. Half of it has already been underpinned. They're not here today because they don't want these trees to be taken away. They bought that home knowing that those trees were there. And that's how so many people that live in St Vigo Way, Hazel Close, why they live there and why they bought those homes. Members, I know we've already heard this, but here we are again. When a tree is gone, it's actually gone forever. For those reasons, we urge the committee to refuse or further defer this application to get the requirements of all reasonable alternatives, including a full structural stabilisation, are genuinely exhausted before sanctioning the loss of a protected oak in the Avondale Home Park area and Hazel Close. Thank you, Madam Chair, for allowing us to speak. Thank you.
Thank you very much, Councillor Cook. Do we have any questions of clarification? Councillor Laming.
Thank you, Chair. You say that the house was underpinned before they moved in and they were the first residents.
Forgive me, I didn't explain myself correctly there. They moved into the home when it was first built in the late 1990s. Approximately 13 years ago, half of the house has been underpinned. Half of it, only half. And they've lived in it from day one as a family. Thank you.
So the house is 13 years old.
it was underpinned approximately 13 years ago. The actual house was built late 1990s.
Thank you.
Thank you.
Councillor Gordon-Smith?
Sorry, the owners of the house don't want the tree taken down.
That is correct. They want their house actually all sorted, not having the tree removed. They bought the home with those trees there.
So who does want it taken down?
The insurance company, because that's basically the reason why they feel that this is the right way to do it, because having a house underpinned is rather expensive.
Any further questions or clarification, members? No? Many thanks, councillors, if you'd like to return to your seats. And now we return to our presenting officer, Benjamin Lewis. Benjamin, do you have anything to add following quite a lot of contributions from our public members? Thank you.
Yes, thank you very much. Firstly, apologies for my mismeasurement earlier, so sorry about that. Please put that down to myself this morning. Yes, so I take on all the points that were raised by public participation. In this instance, the levels monitoring, which is the preferred type of monitoring relating to subsidence, cracks have also been monitored in this instance, but the levels monitoring monitors foundational movement of what we would consider the superstructure. So we would take that as accurate information. The previous case officer and indeed the external expert that was appointed by Winchester City Council agree that the most likely cause is T6 relating to all the evidence. Roots have been found and identified as quercus underneath the foundations at that point, that indicating that this is seasonal movement related to woody vegetation, i.e. the trees to the rear of the property. In this instance, with the evidence submitted and the burden of proof, on the balance of probability, this meets that legal test, and it is still my recommendation to have the removal, to allow the removal or permission the removal of said T6. Thank you.
I'm sure we have lots of questions, members, so we'll start with Councillor White.
So we've established the 38mm, what that looks like, but I don't know if that is considered substantial subsidence, where it is on the scale of how bad the subsidence is. And I think one of the ward councillors mentioned that underpinning of that area of the building that's affected could happen whilst the tree is still there, albeit expensive. Is that the case? Could that happen?
Thank you. So yeah, if you imagine the amount of movement at a single point in a foundation is multiplied within the property, and the report has shown significant cracks within the property. They're measured. It's the NHBC, National House Building Regulations, and there is a crack severity calculator, which that's all within the reports. So, albeit what would seemingly be a small movement on the outside at the lowest point in the building, that causes significant movement within a building, which has been identified here. As regards to the previous underpinning, I'm obviously have been made aware by the insurance report that parts of the house have previously been underpinned. I'm unaware of the circumstances in that case relating to this. We would actually, or the insurers and we would agree in the such that the ground would have to be, or the house would have to be stabilised when the ground is at its wettest. So when essentially our seasonal movement has come back to the soil being fully hydrated, which is at this point. In terms of underpinning with trees still in situ, there is a likelihood that root severance would be required, and it is the it is the requirement that in this case, taking everything on a case-by-case basis, but it would be a recommendation to stabilise post the removal. And
Sorry, can I just clarify there. So you're saying that even if the bit that isn't currently underpinned was underpinned, that tree would have to be removed before that underpinning was undertaken in any event.
So in this instance, with the insurance company meeting the legal threshold, the legal test, they have indicated that no underpinning will commence until the removal of T6 has occurred, in order to facilitate not only the works but also the stabilisation, in as much as if the tree or tree remain, that the causation is still there, and that's there, and that is the process in this situation.
Right, so who was next? Councillor Aaron.
Well, I'd just like to get more clarity about this underpinning, because this all seems to be driven not by whether the tree is, should be kept because it's a TPO, but just because of the insurance company's position. And I just feel uncomfortable about being pushed around by an insurance company when, as one of our speakers said, this is we the council are custodians of this tree. Are you saying it's impossible that what are you saying? Is underpinning first, assuming, just putting aside what the insurance company's position is, but in the view of you and your colleagues, do you think that underpinning first is an appropriate reaction to this situation?
Thank you. In this instance, with visual identification in terms of the stem of the tree being within less than 10 metres of the property and the area that is requiring underpinning, the amount of work that would require, i.e. excavations, in order to carry out the underpinning, the likelihood is you're going to encounter significant structural roots that we would consider. Anything over 25 millimetres would be considered a structural root in this instance. The indications are that the underpinning is not able to take place with T6 remaining, due to that factor, as well as the root barriers have also been considered in relation to that, in the stem bite, the location of the stem being in the being within close proximity. That, as stated in the summary report, has been considered and ruled out as unfortunately in this case not possible due to location of the building and location of the stem. So in this instance, it has been found, my experience as an arboriculturalist, that this instance, that underpinning wouldn't be able to take place at this current time with the tree remaining.
Could I? Yes, Councillor Arrow.
So the thing that's, if there's all these roots are under the house at the moment, if that's the case, removing the tree will make the house go down, won't it? I mean, if these roots are so big that they're causing so much trouble, then removing them are going to cause even more trouble. Is that not correct?
So the size of the roots are not of a large magnitude. So we are talking millimetres, 1, 2, 3 millimetres. But they, in a woody root structure, you have structural roots, and then you have what we would consider fine feeder roots. And the fine feeder roots are the roots that absorb the moisture. They are the sponges, if you like, and they have been proven to be underneath the foundations, and they are the size and type of root that would extract moisture from a soil. So although there are roots that have been found within the trial pit holes and identified as Quercus in lab conditions, they are not directly under the foundations. They are not of a large size. However, they are the type of root within a root system that would be considered to be fine feeder roots, is what we would call them. So they are responsible for extracting soil and moisture and nutrients.
One of the objectors mentioned clay heave, which can happen when a tree is cut down. What is your view on the impact of this?
Subsidence in broad terms is the desiccation of moisture, and heave is the opposite. So the re-wetting of the soil is considered heave. I am not a structural engineer, So it would be down to the structural engineer to adopt appropriate solutions. There are solutions available to prevent heave damage, because heave can also cause damage. In this instance, we are referring to the removal of a single tree within a group of trees. The likelihood is that the removal of a single tree within this group would not significantly impact in relation to heave or soil re-wetting, shall we say.
Right, councillor Laming.
Thank you. We heard that you couldn't do DNA testing because there were a significant number of tree roots in the area which they couldn't link to a particular tree. So if you take this tree down, what's the likelihood of the other trees that require removal?
Thank you, councillor. In this instance, where we have multiple trees of the same species, it's not that, so just to clarify, it is not that we have not carried out the DNA testing. It is in fact that the evidence produced to us does not include DNA testing. DNA testing is not the silver bullet that it would be claimed to be. In certain cases, it is absolutely vital. However, in this case, where we have multiple trees of the same species, it may indeed highlight that the roots found underneath that section of the foundation associate with T6. However, it wouldn't necessarily disprove that other roots are underneath the foundation. So in this instance, where you have a group of trees of the same species, there is also the potential that these trees could potentially be genetic clones, because they may actually be seeded from the same mother tree. So although there may be different genetics within each oak tree, there is, and in this instance, that's why it's been decided not to present it as evidence from the insurance perspective.
No, I understand that. What I was really trying to achieve was make sure that if we did allow that tree to be removed, and they underpinned, whether that would in itself would kill off the other trees, or you'd want to kill those, remove those trees at the same time, because clay is notorious in heave. So yeah, this is a devil and deep blue sea job really for us.
Yes, councillor. Just to confirm, obviously on the evidence that we've had presented to us and that we've reviewed, the most likely candidate beyond the balance of probability is that T6 is the likely candidate due to location and indeed the point of influence on the building. So at the moment, on the basis of the evidence that we have, that meets the threshold for the legal test. Dan would happy to cover legal points.
Councillor Cunningham next, I think.
Thank you very much, Chair. Can you tell me how feasible it is for root barrier treatment to be carried out without the risk of severe root damage to the other trees, please?
Yes, so as stated earlier, root barriers have been successfully used in other subsidence cases where trees have been within a certain proximity to allow the facilitation of a barrier, bearing in mind what I said earlier about the smaller, finer roots being the ones of greater absorption, as mentioned. In this instance, where we have the stem of T6 is less than 10 metres from the property, if you imagine, there would need to be sufficient room to not only install the barrier but carry out any stabilisation works. We would be likely to be what we would consult, possibly within the zone of rapid taper of that particular tree. You are then highly likely to be encountering structural roots. As I mentioned before, any roots that are greater than 25 millimetres we would consider to be have a structural purpose. So by virtue of its location and the location of the property, in this instance, it's been considered, and as I said, it's noted in the report by the insurers that they have done an analysis, and unfortunately in this case, root barriers would not be applicable or would not be able to be installed in this situation, unfortunately.
Can I just follow up on that? So root barriers wouldn't, in the insurance company's view, solve the problem with the tree that they're applying to have cut down. But would root barriers be necessary to ensure that the other two trees that I believe are fairly close don't in the future become an issue?
Thank you, Chair. Yes, for the purposes of determining this application, we are looking at T6 and the application to remove T6. The structural solutions or the engineering solutions may or may not consider root barriers for adjacent trees. That hasn't been disclosed.
I think we're
from the
concerned
insurers.
that we don't give permission for one tree to come down and then find that in 2 or 3 years' time, they come back with another application to cut the other two down for reasons that, if they acted in a particular way, could have been saved, if you like. So that's really why I'm asking.
Yes, in terms of the structural stabilisation work relating to this particular part of the building, they have noted structural stabilisation within the report only and not consideration of root barriers. I would consider that in this instance, root barriers may or may not be applicable for those other trees, depending on root size and ingress to that point in the building. But going back to the presentation, looking at the location of T6 being the most likely cause due to its location to the rear of the property. So I can't comment on the installation of root barriers in this instance.
Right, that's very confusing. Okay, Councillor Langford-Smith, please.
Thank you, Chair. Can I just confirm that points 8 and point 7 on the movement markers are where the largest level monitoring difference is, and that's the 46 millimetres, and that's on the conservatory?
Yes, it's to the rear of the property. It's including the conservatory. Yes, level point. It's 0.8 shows the greatest movement, which is the northern side of the conservatory.
And the conservatory would have been added after the house was built and subject to very different building regulations than a house, so it's likely to have much shallower foundations.
I obviously, as an arboricultural officer, I'm unaware of the particular building regulations relating to that conservatory. I would note that although the conservatory is moving, other parts of the house are also moving, which would have been on the original foundations of the original footprint.
Councillor Williams.
Thank you, Chair. I know there's been, and we deferred last year for sort of DNA analysis, and I think it's quite clear in the report, obviously, that the roots are fused. It would be quite difficult to identify specifically from the DNA analysis. Is there a risk that if there was DNA analysis, the insurer may come back and it matched, say, all 3 trees identically? Is there a risk the insurer could come back and say, well, actually, we want all 3 trees taken down now?
If the root DNA analysis was inconclusive or came back compatible to more than one, then ultimately that may be a recommendation that the insurers put forward, yes.
Can I ask, has the true immunity impact been taken into account? As was pointed out, we've got photographs from the side of Hazel Close, but we haven't seen photographs of the tree from the park side, Park Homes side. And there are a lot more people living there, and obviously the impact of losing the tree on them is going to be significant. Has that been properly taken into account?
Yes, thank you, Joe. Yes, it has been, although the images produced in the presentation are from they're indeed from the original original committee, but they obviously focus on the street view, shall we say, from Hazel Close. The amenity value overall of the tree from both sides has been considered. The tree forming part of a linear group, from amenity terms, the loss of one within a group is more acceptable than the loss of a single tree standalone with no other trees within the vicinity. Assessments are carried out like in this way for visual amenity. The Halliwell system is a system that is used, and the tree within a larger group of trees would be considered to have less amenity value than those of an individual character in an individual setting.
And the Woodland Trust requires that we use an evidence-led approach when assessing whether a TPO should be removed. Are you confident that we have used a proper evidence-led approach?
Thank you, Chair. Yes, as I've said, the guidance on the Woodland Trust, but also other guidance that is available out there, DNA analysis, as we've said in this instance, would not add anything to the evidential weight, unfortunately, due to location and species that are being discussed here. To be clear, that the TPO will remain, so there won't be a removal of the TPO. So what we will allow is we are consenting to the removal of T1, which is the number within the TPO, T6 on this. We are consenting to the removal of that tree, which is protected as part of a wider group of of trees, which form the linear group and an area group to the north. So the TPO itself, which is 1212, will not be removed, but the works that have been applied for, it is my recommendation and the recommendation of previous officers that we allow them works or consent to those works. So just to clarify, the TPO won't be removed. It will be that T1 is allowed or permitted to removal.
And will the protection that T1 has be placed on the hornbeam, which is to replace it?
In this instance, no, it is not automatically protected following it is conditioned as part of a replacement, as in it is a condition of planning that you are by approving the removal of. Apologies for the confusing number, because it is T1 in the TPO, but T6 on this application. So I'll refer to it in terms of this application. We are permitting the removal of T6, and the new hornbeam carpet specialist will be a condition of that permission, but it won't have automatic preservation order protection at that point.
And could I ask our legal advisor, what are the legal implications of all of this? It's the insurance company that is requesting that the TPO is removed on T6. What is the likely financial risk to the council if we decided not to acquiesce with this application?
Thank you, Madam Chair. So ultimately, you'll be probably subject to a claim. The report, I think, mentions a figure of 50,000. Correct me if I'm wrong, Mr. Lewis. So this is the key consideration here, that the council will be opened up to a potential claim. There's been conversations about other things which perhaps are not relevant to your assessment. So one of those is the amenity value of the tree, unfortunately, is not a matter of law here. The actual value of the tree in the street scene, what it contributes to the locality. Indeed, if you, for example, the verdant nature of that particular area of Coldham Common, it's not relevant. Ultimately, the legal test is under the tree regulations. If on a claim under this regulation, this is regulation 24, a person establishes, this is the key fact here, a person establishes that loss or damage has been caused or incurred in consequence of. So here we have the legal test. If they establish loss or damage and the causal factor, what we call causation, has been as a result of the refusal of any consent required under these regulations. So if you are minded to refuse today, immediately that regulation is engaged. The grant of any consent subject to conditions. So even if you're minded to grant, but you put conditions on, they can also seek to challenge the actual grant with conditions. Very unlikely in this instance, because they want removal, you've consented to removal, albeit you've added a condition for replacement planting, or the refusal of any consent agreement or approval required under such condition. The person shall, subject to paragraphs 3 and 4, be entitled to compensation from that authority. So to read that with the key relevant points engaged, if on a claim under this regulation, a person establishes that loss or damage has been caused or incurred in consequence of your refusal of any consent, that person shall be, subject to paragraphs 3 and 4, be entitled to compensation. So that's the test. not whether or not it contributes to the amenity of the street scene, how wonderful it looks as a specimen or species. Indeed, the amount of species that live on that tree, I think 2000 was mentioned by one of the, that won't be before the court here. The ultimate points before the court are what we call causation. Now, the tribunals have gone on to clarify what this actually means with reference to case law. There's one very recent decision, the case of Chubb European Group against Enfield London Borough Council. It's in the upper tribunal of the Lands Chamber on the 14th of February 2025, so very, very recent. And indeed, Dr. Dobson, which is the council's expert in this particular case, Dr. Dobson there was called as a witness for the claimant. So acting on the other side of the fence, as it were, for the insurance company. Here you've got Dr. Dobson advising the council in relation to this particular claim. However, what the key point to take away from all of this, the upper tribunal there was faced with a similar claim. In this particular case, in Enfield London Borough Council, the property is detached, traditionally constructed two-storey house with attic rooms under a hip roof, built in the early 20th century, two-storey extension to the rear right-hand side. The rear garden of the property backs onto grounds belonging to Bush Hill Park Golf Club, in which is a row of trees protected by a TPO. Note the analogy here, this tree is not on the subject property. It's in the Avondale Hollanday home area. I think it's Avondale, or yeah, thank you. The row includes close to the boundary of the property 2 oak trees, which have been referred to as T1 and T2. T1, the subject of these proceedings, is agreed to be 28 metres high. It's a 29.15 from the garage, 31.65 from the extension. T2 is also 20 metres high. There are also 2 cypress trees in the rear garden, one of 8 metres high, and so on. So the analogy is very, very similar. You have a row of TPO trees not on the subject property, and one particular tree here is implicated. So the tribunal judge went on and actually went on to explain what was engaged. He agreed it was the particular regulation I've already recounted to you as a matter of law. And he outlines the key legal principles to consider, which is for you today. The judge there quotes, counsel for the parties agreed the following statement of issues. Was the oak tree, T1 in this case, T6 for you, on the claimant's case, an effective and substantial cause, not the sole or predominant cause, or on the authority's case, the natural and probable cause of subsidence to the property? It was common ground that the evidential burden is on the balance of probabilities. You've heard here criminal standards by the speakers. That's not the case. It's on a balance of probabilities. That is, i.e., is it more likely than not? That's the civil test. Not beyond all reasonable doubt, which is the criminal test. Is it more likely than not that T6 is implicated? Not whether it's necessary beyond all reasonable doubt. It's on a balance of probabilities, i.e., is it 51% more likely that T6 is causing the subsidence here? Note that threshold. It's not to the criminal standard, which is beyond all reasonable doubt, or for criminal law so that you can be sure. You don't have to be sure. You just have to conclude that it's more likely than not. So the judge goes on. So he says, was it the natural and probable cause to the property? Having regard to the application for consent to file and the documents and particulars accompanying it, was the loss to the insurer, i.e. the cost of underpinning, reasonably foreseeable by the authority when consent was refused? Was the loss reasonably foreseeable by the claimant and attributable to its failure to take reasonable steps? And what is the quantum of loss attributed? He then goes on to summarise all of this, and he says, simply stated, the issues to be determined for you are causation, foreseeability, and the quantum of loss. That case went on for 2 days. Dr. Dobson was called for the claimant in that case. So that's a brief summary here. What you have on the facts and what I can see from the reports are you have proven soil desiccation. You have intact drains, i.e. the drains are not leaking and causing the soil to desiccate. That then means that the roots and the uptake of water are probably the cause here for subsidence. If the drains were leaking into the actual clay and then it was drying out because of the drainage leak and then re-leaking, that could be a factor. But here, the drains are intact. In this particular case, the drains were not intact. So the judge said, well, actually, I can't say if it's the trees or the leaky drains. Here you've got intact drains. You've got soil desiccation, clay subsoil type. You've got root analysis to say that is Quercus rabor. You've got crack monitoring records. You've also got movement records, and you've also got a tree within the zone of influence. Now, that taken together is a matter for you and your judgment. I can't give legal advice in open session, but I can explain to you the principles that what the law are, because it's a public record. Regulation 24 is a matter of public record. But those are the facts here. That's what you've got. And what you need to decide is, with this package of evidence, i.e. what they've shown, coupled with that legal test, do you feel the case has been made out? That's a matter for your judgment. I can't obviously give legal advice in open session, but I can tell you what the law is.
What was the result of the London case?
The London case, bear with me, just got it open here. The judge there at paragraph 62, the first and key factor to be considered in determining a causal relationship between T1 and the damage at the property is the evidence of desiccation in the subsoil, which would indicate removal of moisture through the roots of vegetation leading to subsidence. Much has been said about desiccation in all the expert reports, but in the end, the engineering experts agreed that there was no evidence of severe or very severe desiccation in the subsoil. There was speculation as what might have happened in the subsoil in a period of over 2 years, during which the movement of structures were recorded, but no further site investigations were carried out. When it was deferred here, you have further investigations in terms of the monitoring. The absence of evidence of desiccation is a significant weakness in the claimant's case for causation in respect to damage for the extension. As the authority has pointed out, there was no site investigation at all beyond the garage. Here you've got trial bore pits. I think you've got 3, one by the conservatory at its juncture where it meets the main body of the main house, and there's some around the side as you look on the report to the right. I don't know what elevation that is. The second factor to be considered is the evidence of seasonal and cyclical pattern of movements of structures, which would indicate root-induced shrinkage and recovery. The engineering experts agreed the movement at points 10, 11 and 12 around the garage did display a seasonal pattern of movement, but they were not agreed on the mechanism. Mr. Freeman's theory was that this was a result of subsurface erosion caused by water running down the slope under the foundations as a result of drainage failure. Mr. Allen's response was that such a mechanism would not have commenced in 2014 as a result of drainage failure, and in any event, the drains were repaired. The judge goes on. I conclude that whilst there is no obvious evidence of seasonal shrinkage and some recovery, I conclude that whilst there is obvious evidence of seasonal shrinkage and some recovery around the rear of the garage, there's only speculation as to what might have happened in the subsoil to cause progressive downward movement. Without any factual evidence, the causation argument for moving the garage is weak. For the extension, the only significant evidence of seasonal shrinkage was at point 6. He goes on about water recovery. Finally, I must consider whether there's evidence in documents and whether or not the roots would extract sufficient moisture to cause subsidence. He says that the roots were found in the area. Dr. Dobson considered research confirmed these distances within the potential zone of influence of an oak tree, and it was likely that the roots were plentiful in areas outside the borehole. My conclusion from the evidence and the expert opinions is that it's not been demonstrated that T1 and its roots extracted sufficient amounts of moisture. The distance from the tree to the structures, the roots identified in June were few and juvenile. He also concludes the evidence on desiccation and seasonal movement does not establish on the balance of probabilities the causal link between T1 and subsidence. He factors into the fact of his conclusions as well the drains, because it was unclear whether or not soil desiccation was due to roots or the drain failure.
In that case, the tree was saved.
Yes, he having decided factual cause. Well, the monetary claim against the council for refusing to allow the consent to foul.
So there was no.
So the
claim.
monetary claim was refused.
But you're saying that the evidence is much clearer in this case against the tree.
That's not for me, councillors. That's for you. But what I've done is summarised, obviously, what that evidence says.
Right. Okay. All right. Okay. So basically, okay. All right. So we open ourselves up to a claim by the insurance company of around 50,000, which is what it says in the report. If we don't agree to that before, Councillor Cunningham first.
Thank you, Chair. Just for clarification purposes, Mr. Lewis, can you tell us whether there is already structural damage to the main building, the main house itself, please?
Thank you, Councillor. Yeah, detailed within the report, there is obviously images taken where areas of the house are focused on, and yes, there is clear structural damage within inside the house. The levels monitoring, as I've said, monitors the movement of what we would consider the superstructure. It also has had crack monitoring, which would confirm that, but internal cracking is visible as per the report provided from the insurance company, and that is still the case.
Thank you very much. Thank you.
And Councillor Langford-Smith?
Thank you, Chair. We've been told when the house was built, the trees were clearly there a long time prior to the house being built. Building regs were very different when the house was built and quite clearly insufficient because those regulations have now changed. Footings now near trees on clay soil now need to be 2.4 metres rather than the 1.2 that they used to be. So the insurance companies clearly, when they insure these buildings, are hoping that planning authorities will be risk averse and roll over to their demands, clearly due to the costs involved. Insurance companies always ask about the proximity of trees when they consider insuring a property, so they will have been aware of the risk that this property may need to be underpinned. So are we not reasonably justified to ask for all other options, such as underpinning, before agreeing to fell the tree? That felling the tree should be an absolute last resort.
Indeed, Councillor Mr. Lewis.
Thank you very much. I agree with you that building regulations have improved over the years, and obviously we're now working to the latest NHBC regs, depending on the species within influence and the height. That is how it's calculated, whether or not you need, what depth your foundation is, but also whether you require specialist foundations. In this instance, and echoing sort of the legal advice regarding the threshold that is required in civil claims, the previous evidence which Dan summarised is still the case in as much as drains have been ruled out due to CCTV surveying. We have laboratory tests confirming the species of the roots found underneath foundations. That's a key evidential test. And notwithstanding that we have a number of trees, but this particular tree is implicated and is well within the zone of influence on this particular property. In terms of carrying out underpinning prior to the removal of T6, as this is a third party tree here, we are basing our decision, or I would like you to base your decision on the evidence that has been brought before you relating to the legal threshold. And it would be in this case that the removal has met that threshold of test in terms of the evidence we see before us, and that being the most likely cause. I won't repeat, but essentially now they have indicated through their reports and through the numerous months, 30 months is a considerable time in terms of levels monitoring. So we essentially have two cyclical seasons where we've got 2 summers. It has indicated that there has been further movement this summer just gone as opposed to the previous summer. That would further indicate vegetation being the cause of subsidence. And in this instance, my recommendation still stands to allow the removal of T6 in this case.
Madam Chair, perhaps I can assist with this point about foundations. So I'm looking at the JCA report. This is the report submitted, the arboricultural report on behalf of their client 360 GlobalNet. And in that particular report, they talk about the foundations, and it says in this particular paragraph at 3.2.1, foundation types and depths, please refer to the site plan at Appendix 2 for indication of the trial pit borehole locations. Trial pit borehole 1 revealed a 1,200 millimetre, so that's 1.2 metre concrete foundation at a maximum depth of 2,000 millimetres, so that is 2 metres below ground level. Trial pit borehole 2 revealed the same, a 1,200 millimetre concrete foundation at a maximum depth of 2,000 millimetres below ground level. Borehole 3 was a remote borehole only, therefore did not reveal a foundation. So the point about the conservatory having a different foundation is not made out. because the foundations are at the same depth and level as found by the untried pit boreholes. So TH1 is to the rear of the property I'm looking at now. It's at the juncture of the conservatory where it joins, if you like, the rear elevation, and it's at that apex of the right angle. Then TH2 is on the flank of the main principal dwelling, so away from the conservatory, which is on the rear elevation. So the trial borehole pits reveal the exact foundation depths at the same depth.
Thank you for that clarification. Councillor Williams, you have a question?
I have two, if possible,
Yes.
if you'll allow me. I was wondering if, so we mentioned, I can't remember who mentioned it earlier, but in regards to the replacement tree, it was said that we couldn't TPO that tree. Would it be possible, so the T6 is right on the border of a blanket TPO area. Would it be possible to condition it being planted in that blanket TPO area? And if so, would that then protect the tree?
Thank you, Councillor. In essence, it would not automatically protect the tree if it was placed within the area order. There's varying types of tree preservation order. An area order, in this case here, protects trees that were of a certain size or present at the time the order was made. A woodland TPO, which this isn't, but woodland TPO covers everything, no matter of size or age, and whether it's natural regeneration or plant, that covers everything within that woodland area. So in this instance, it's not to say that it couldn't be protected by a TPO, but by virtue of it being planted as a condition, it isn't automatically protected. That it may actually be able to have a TPO placed on it as an individual, but it wouldn't be subject to this particular group, and it wouldn't be automatic protection, which I think is the question earlier.
Yeah, thank you. And then the second question, I don't know if it's worth hearing any specific legal advice. I don't know what other members feel like.
We would have to go into closed session to ask Daniel for his specific legal advice. So is that a proposal, Councillor Williams?
If other members think that would be beneficial, then I would be happy to propose it. Sorry.
All right, can I see all those in favour of going into closed session? And those against? Right, so we go into closed session. That was 5-4 in favour of going into closed session. So could I ask members of the public and member of the press, and I think that's it, to leave the room, please?
Claire, this would be because of Schedule 12A, matters relating to legal professional privilege. Okay, thank you.
Right, my apologies for that slight closed session, but members now have the information that they're required to make an informed decision, I believe. So if there are no more questions, we will move to debate, members. Who would like to start? Councillor Williams?
Thank you, Chair. This is a very obviously difficult decision, and you know, we've spent a considerable time trying every opportunity, I think, to try and save this particular tree through probing, and I do feel as though you know, it is obviously awful to approve this tree to go. However, we are in a sort of situation whereby, you know, the original application was for 3 trees. We've then come down to 1 tree and deferred last year to today to try again to save just that 1 tree. And again, incredibly difficult decision before us. However, the balance of probability of a substantial legal claim against the council, I think on balance at this point is something whereby we will have to approve this TPO being lifted. Again, a very hard decision. However, you know, if we were to further defer this for further investigations, I still feel the evidence before us will not be outweighed by further investigations up to and including sort of DNA analysis or root protection barriers, because again, the root cause of the subsidence of this home has been, I think, beyond that sort of 51% civil liability that Mr. Lucas was telling us about has been reached, and I don't think will be overturned. So I think it's incredibly sad in this situation, and we do, as a committee, really try and say every single tree that is protected. As I'm sure, you know, everybody else will agree, but I think unfortunately in this decision we will have to lift the TPO, and sadly I think that's going to obviously mean the loss of the tree.
Thank you. Anybody else? Councillor Langford-Smith.
Thank you, Chair. We've heard earlier that felling of trees should be unavoidable and it is not preferable, and that felling should literally be a very last resort. But the evidence that we've been presented with is quite clear on the balance of probabilities that it is more likely than not that the tree is causing the issue. So I don't believe that we've got a choice in this situation, unfortunately.
No more contributions. All I'd like to say is that I agree entirely with my colleagues. It's incredibly sad that we have to put filthy lucre before the tree, but that is the reality that we live in, I'm afraid. I am pleased to see that we are conditioning its replacement with a more suitable species, and hopefully that tree will be very soon a very loved and appreciated local amenity. So can I move to the vote, please? Can I see all those in favour of this application to remove the TPO on that 1 T6 tree, please? All those in favour? That is all members, so that application is approved. Thank you. That's the end of today's planning committee. Thank you.